Hey, everybody. Welcome to Thursday night. I am back here on the YouTube channel, the Consumer Warrior YouTube channel. Glad to be back. Sorry you missed last week, but each and every Thursday night, I try to be here to answer questions, have discussions about defending debt collection lawsuits, particularly those by junk debt buyers like Portfolio Recovery, Midland Funding, Unifund, all those guys. And then we talk also bankruptcy, those kind of things. So, the way that we like to do it, if you are new here, is in the comment section over there, is to go ahead and put your question that you have, and we can talk about it. My disclaimer, as always, is that even though I am a licensed attorney in the state of Arizona, this isn't legal advice, doesn't create any type of attorney-client relationship because we've likely never met. I don't know the specifics of your case, and believe it or not, I don't know the laws in every single jurisdiction. So, if you need legal advice, you need to contact an attorney in your particular state. So we have a bunch of regulars here. I can tell you we have like Dave Lamb, who contributes to the show each and every week, as well as Marcos. And I appreciate it, guys. Every week you're here supporting it. Sincerely appreciate it. All right. So something I wanted to throw out there, and maybe I can throw in the comments. A while back, if you are a regular visitor to my Consumer Warrior YouTube channel, you will know that I created a private Facebook group, and it was a members-only thing, and there was a kind of a nominal monthly fee to be involved in it. If you are a member of that, you probably got an email yesterday saying that I terminated the memberships. I'm not stopping the Facebook group. I'm actually opening it up. I'm opening it up to anybody free of charge who wants to participate in it. I think that'll be a better interaction. People will get more out of it if we can get more people involved in it. So I'm going to put a link here in the comments. And this is over on the YouTube channel if you're watching this on Facebook. But it's the Consumer War. You can click on that. There's a few little questions you have to apply saying you're basically going to follow all the rules, and then I'll approve you to be in there. But that's a great place where you can share ideas with other people who are going through similar type things. I do contribute there as well as far as dealing with questions. But if you want to participate in that, there's no charge anymore to do it, and I appreciate you jumping in and do it. So one thing I wanted to start with for tonight is a question that from the comments that I get in the YouTube channel. This question said, I'm being sued by a junk debt collector in Maine. Can I call the lawyer that's suing me before we go to court and try to settle my debt? And there was a bunch of feedback that people had given this person, and it's good. And truthfully, there's no right or wrong answer with this. But one of the main points I wanted to bring out, if you've been sued by a debt collector, there may be some hesitancy to reach out to them. You're worried about what you can say or what it's going to do to the statute of limitations, things like that. First of all, if you've been sued, the lawsuit's actually been filed against you. The statute of limitations is either an issue or it's not. It's something where they've either met it or they haven't, because the statute of limitations governs the time from when you miss a payment until they can actually file the suit. So if they filed the lawsuit, there's a good chance that the statute of limitations is no longer an issue. But more importantly, I think you need to understand is that there's no real harm in reaching out to discuss settlement. And that's because of the rules of evidence. There's a rule called Rule 408 in most jurisdictions. And it essentially says that settlement discussions are not admissible in court. So if you were to reach out to, let's say, this junk debt buyer here that this person in Maine's dealing with, and say, hey, I see you're suing me for $5,000. I'll pay you $1,500 to get this thing to go away. We don't have to litigate this anymore. We're just done with it. They can't then turn around and say, hey, judge, he's already offered us $1,500. Clearly, he owes the whole amount. They can't do that. Settlement discussions are not admissible. And the idea behind the rule is, hey, they want the parties to talk and negotiate and see if there's some kind of middle ground that can be reached. So that's something to be aware of, that there's no harm in doing it. One of the comments said, well, you can litigate it and put yourself in a better position to get a settlement. And that's true. Sometimes, though, right when you get served, if your whole goal is just to get this over with as quickly as possible, that's not a bad time, because the lawyers haven't had to put a whole lot into the case so far. You're not paying court filing fees, all that kind of stuff. So, all right, let's see if there's any questions here tonight. Rashad, 24-year debt collector here. He's love the channel. Thanks for the recon. It's a vicious cycle. You know what, Rashad? Something that you're bringing up is I tell people all the time, none of us are immune from financial problems. I have filed more bankruptcies in my career for people who make 10 times what I will ever make than you would believe. And so often, and sometimes I think I brought this up a couple weeks ago, people are can be very judgmental about financial issues. Yeah. People make bad choices at times, but you never know what's going to happen. There might be a worldwide pandemic that hits. There might be the Great Recession, those kind of things. So those are the types of things that can impact people. And so appreciate you, Rashad. Don't share my secrets, though. These are they're not too secret, but I'm putting them on YouTube, I'd say. All right, let's see what Ike has. Ike, thank you for the support of the channel. You have an upcoming trial with Velocity. Velocity is a junk debt buyer, kind of lower level debt buyer. They provided generic spreadsheets of billing instead of actual statements. Can I challenge this? The answer is always yes. You can challenge everything, and particularly if something is out of the norm. If it's something like this, where instead of like a monthly statement, one thing I see a lot that debt buyers will do is they'll attach a bunch of monthly statements, but if you look at them, they look different than what you actually get in the mail. And the main thing is you'll see like they won't have like the logo, the MasterCard logo or American Express logo or whatever it is. And it's because they're not the actual statements. They're not photocopies. They're recreations. And one way that you can tell is I actually had a case once where I was looking at the monthly statements, and the statements were supposedly from something like, 2000, 2001. This was a long time ago. But they were printing them out for the court, and there were advertisements on the back, like how sometimes there are on your credit card statements. And they were advertising, I believe it was like the iPhone. The iPhone had not been invented at the time that those statements had originally come out. And we were able to bring that up and point out the inconsistencies of that. And, the video that I released yesterday, I'd recommend you go back and take a look at that if you haven't had a chance to look at it, because I had a trial yesterday against Midland Funding. And I talk about how important it is to know your documents, go through things, checking account numbers, things like this. If it's just a generic spreadsheet, see if the account numbers line up, the addresses line up, all that kind of stuff. So not only that, and I'll go circle back here, Ike, to your question. If they are generic spreadsheets and not the actual statements, you can raise an objection. If it's in trial, you can object for foundation, authentication, basically saying, where did these come from? Who created them? Why don't we have the original statements? And you can try to get them thrown out that way. So hopefully that helps with that. But anytime you're getting something that's made directly just by the junk debt buyer or by the debt collector and is not something that looks like an original documentation, then you absolutely need to make an objection to it. So, all right. We're not having a lot of questions this week. Maybe that's a good thing. Maybe people need a rest from all of this. And so we don't have to go much further tonight because I didn't. Let me see if I had any other questions that I was going to throw up there. That may have been it. So I think that is. I am going to put up here on the screen real quick the Facebook group. So the Facebook group, I think, is something that could be really beneficial to people. Just go to facebook.com/groups, Consumer Warrior. I will approve you. And then, like I said, it'll take this conversation, I think, and take it. It's not going to take it offline, but it'll take it to a different platform where it's a little more easier to have the kind of give and take that is necessary to kind of, flesh these things out. So head on over there and check that out. All right. Let's see. Natus. I didn't see you had a question. Put the question up one more time, and then we can take a look at it. All right. I think then that is going to be it. But because I'm not seeing any other questions. Sorry, guys. We're going to end it a little bit shorter this week. Oh, wait. I'm just kidding. Maybe. Natus Freedom. I'm going to, let's see here. Sorry, I've got the dead air going. I need to get an assistant or somebody. Well, let's see what my Harley. I filed a response to my Midland lawsuit and just received a court date. The petitioner law firm has called me. Is that okay? Um, yeah, it's okay. I mean, well, I should say this. If you filed your response and you filed it yourself, you're not represented by an attorney. If you're represented by an attorney, they've got to go through your lawyer. But if you're representing yourself, then yes, they can contact you directly. It's going to be necessary. Most courts require that the parties exchange phone numbers, emails, that kind of thing, so that they can correspond throughout the thing. They also may be reaching out to talk about what do you call it? They may be reaching out specifically to talk about settlement. So that's one way to take a look at it. All right, I think that will be it. That will be it for today. If you have any other questions, like I said, go ahead and click on the thing over there for the Facebook page. That's a great place to post questions. I will check those out tonight here before I go home, and we will answer those. And it's not just my answers. There's other people in there that have gone through this, and they know what you're dealing with. So check it over there, check that out, and I will